in Nashville. I know you were with us in June on one case,
Yes, Your Honor.
and I believe were you up here in June?
No, Your Honor.
Okay. I'm sure that everyone is familiar by now with the Supreme Court's recent order requiring masks to be worn. The court, members of the court are going to be wearing their mask, may pull it down to talk. I haven't. If you have a hard time hearing me, then let me know if I ask you a question. What we're doing is if the attorneys want to remove their mask while you're arguing, actually speaking, then that's okay. Because we're so very socially distanced. You're not anywhere close to being within 6 feet of anybody, and neither are you. So and you're familiar with it, we encourage you to, you're welcome to come up to the podium, but we encourage you to just remain at the table. You can sit and just, the microphones are there for you to use under the circumstances that we have today. And under this, not just today, but the whole general situation. To my right is Judge Bobby Holloway from Columbia. To my left is Judge Tim Easter from Franklin, and I'm Tommy Woodall. I'm from Dixon, Tennessee. As both of you are well aware, that each side has 20 minutes. If you represent the appellant and wish to save some of that 20 minutes for rebuttal time, just let us know when you start. I will be keeping time today, and if you start to get into your rebuttal time a little bit, I'll let you know so that you can argue accordingly. Are there any other matters that need to be taken up by the court? No. Okay, would you call this afternoon's case?
State of Tennessee versus Edward Walsh.
All right.
Good afternoon, Your Honors. Todd Ridley on behalf of the appellant, Mr. Edward Walsh. I'd like to reserve 5 minutes for rebuttal.
Okay.
And if there are any issues hearing me, I can pull the mask down, but I'm going to try to keep it on for the time being. So just
I can hear you well. If you'll adjust that, you can pull that microphone towards you a little bit. I think we're being broadcast again like we were in June. So, okay.
Okay. Well, okay. Again, Todd Ridley on behalf of Mr. Walsh, and I'd like to reserve 5 minutes for rebuttal.
All right.
But I'll go ahead and get started with kind of our central issues for today's appeal. The first, and these are all spelled out in the brief, but the first is the denial of Mr. Walsh's motion to sever the offenses. So there are two central offenses that are involved in this case: first-degree premeditated murder and abuse of corpse. The killing of the victim followed by her subsequent dismemberment. Now, there are a few different ways to approach this, or a few different ways I want to talk about this issue, and they're kind of dictated by the way the trial court and the state really handled the motion below. So the first thing the trial court did at the state's urging was it found that these two offenses were subject to mandatory joinder. They were not. Mandatory joinder, as articulated by the Tennessee Supreme Court, requires an inextricable connection, meaning you cannot separate one offense from the other. In this case, the trial court found that you could not separate the murder of the victim from her subsequent dismemberment. You can. Those two offenses were broken up in most critically in time. So there's a killing, and then there's a long break. In that break, Mr. Walsh goes to work, he goes to sleep, he eats. Only then does he start the process of dismembering the body. And that dismemberment is what constitutes the abuse of corpse. So that big time break is what makes these two things not inextricable. So when the trial court found that they were inextricable, it erred. That error is subject to this court's de novo review. And so for the first thing that Mr. Walsh would ask this court to do is reverse the trial court's denial of his motion to sever, because it erred when it concluded that these two offenses were subject to mandatory joinder. That saves this court the trouble of having to go through the factors of, what under what circumstances can you sever mandatorily joined offenses? There's no need to do that because these two offenses were not subject to mandatory joinder. So that's the central point that I want to get out on the issue of mandatory joinder. But the trial court also did this at the tail end of its ruling, and it was more than an afterthought, but it was a little bit of an afterthought. It said, by the way, I'm also going to find that these two offenses were subject to permissive joinder. And under that standard, they should still not be severed. So it's a kind of a two-part ruling that the trial court did. But even in the second part, on permissive joinder, the trial court still erred. It erred in this case because these two offenses should have been severed if they were subject to permissive joinder. And that is because these two offenses, while there's some bleed over in what might be relevant for one and into the other, were not so intertwined that you had to have them. And so everything that was related to one offense wouldn't necessarily be admissible in the other. So Mr. Walsh, I would be the first to admit that there's going to be a little bit of this that's going to be relevant. Now, it's going to be relevant if Mr. Walsh did something to the body after the killing to show premeditation. That's relevant. But what's not relevant and what's not going to come into a trial of the other is everything about this killing, everything about this murder, all of these pictures. They are not going to all be relevant in each other's trials. And they're certainly not all going to be admissible under Rule 404B. And so that last part is a critical thing. If you're going to have these two offenses joined together in a single trial, every piece of evidence that comes into one must come into the other. That's simply not the case here. It would not be admissible in a trial for abuse of corpse to have all this information about how the victim came to die, the victim's prior history with the defendant. None of that would have been admissible in an abuse of corpse case if that was the limited issue before the trial court and before the jury to decide. So when the trial court said, even if they aren't subject to mandatory joinder, I'm going to find they're subject to permissive joinder and deny severance on that ground, that was also in error. And now that we have kind of error established, the important thing is prejudice. It is incumbent upon the defense, in this case, Mr. Walsh, to establish that this denial of the severance motion caused him prejudice. And here, the denial of the severance motion infected everything about this trial, from the beginning to the end, from defense strategy to the state's closing argument. So from the outset, here's how it affected the defense directly. Because the abuse of corpse charge was included with the murder charge, the defense was effectively forced as a matter of strategy to concede guilt on one of the central charges, not one of, the other central charge before the jury. So that's how it first affected the case. Then during voir dire, one juror even went so far as to ask, I'm not sure I could separate these two things. That juror, I'm not sure, actually wound up on the jury, but that's not the point I'm making. The point I'm making is that everything about this case was infected by the trial court's decision to keep these two charges together. Or even someone just hearing about the case for the very first time, a juror on the panel says, I don't see how I could separate these two things. That juror was correct in that concern. These two things can't be separated in the way the trial court wanted them to be separated. So third, just the state's proof in general. The state's proof went back time and time again because it had to include it chose to include all of this information. And when it did so, all of this came in where the jury is going to hear all of these things together and can't separate them. In the state's own closing argument, the state indicated you can't separate these two things. And because you couldn't separate these two things in the way the proof was presented, the denial of the severance motion caused Mr. Walsh prejudice. He could not present the case in the way he would have preferred to present the case, and the state utilized the lack of severance to try a case that it shouldn't have been able to try. So all of that taken together, there's clear error. These are not subject to mandatory joinder. They're not subject to if they were subject to permissive joinder, they should have been severed because they weren't admissible in each other. And that failure or that error by the trial court caused Mr. Walsh prejudice. So all of that taken together is reversible error. And that reversible error should mean that these two convictions are reversed and the matter sent back for a new trial. And at the new trial, they can keep them separate, do it the proper way, and see what the jury does with it. But keeping them together was an error that caused real damage. So the second issue I'd like to talk about, if there are no questions about that first one on the severance, is kind of I believe the state in its brief kind of joined these together, and I will too, just for clarity, involve kind of the Goolsbee testimony. This is testimony from an individual named Herman Goolsbee, who was kind of the only semi-contemporaneous witness to what may have happened. And what happened that is kind of the subject of this appeal is a bit of hearsay that Mr. Goolsbee testified to that was subject to a fair amount of mid-trial litigation. None of this was decided pre-trial, but it was litigated pretty heavily in the moment. And that's this. So Mr. Goolsbee is called to testify, and he says he heard someone, presumably the victim, at some point in time, though we don't really know when, say something to the effect of, "Ed, don't hurt me." Then says he heard a crash, and the state used that bit of testimony to say that Mr. Walsh caused the victim's injuries. That's the critical piece of evidence for the state because they have no other eyewitnesses, no other scientific proof that could tie Mr. Walsh to the victim's death. So Mr. Goolsbee's testimony was critical for that purpose. But the "Ed, don't hurt me" language is what's critical. When Mr. Goolsbee offers this testimony, or even before he offers it, the defense offered an objection. Trial court refrained from ruling. And then there was kind of a long back and forth where the state said, well, this statement, "Ed, don't hurt me," is subject to the excited utterance exception. Therefore, it should be admissible. Trial judge says to the state, well, you're going to have to establish a foundation for that. They try to. They fail to. So the trial court sustains the objection. Then they try again, and they try again, and they try again. Each time, the trial judge becomes more and more involved in the proceeding. So it's not the state anymore asking the witness, how is this statement made? Under what circumstances did you hear it? It actually winds up being the trial judge who is doing most of the questioning that's essential to getting to the excited utterance exception. And eventually the trial judge gets the witness there, helps the state's attorney get the witness there, and eventually overrules the objection and allows this testimony to come into evidence.
And all this is outside the presence of the jury.
No, not necessarily. There is some of this that is very much in the presence of the jury. Now, I'll be the first to admit that the record on this, it goes back and forth in the transcript between jury in and jury out, but there's a fair amount of this that is in the presence of the jury. So the point being, though, after it comes in, we have two central issues that we want this court to consider. The first is this. Mr. Walsh's right to a fair trial was violated by the trial court's actions in this case. What the trial court did, and I certainly understand why it was doing it or how it was doing it, but the trial court was hearing a state attorney make an argument for an exception to the hearsay rule. The state's attorney was not asking the questions that the trial court wanted answered. Those questions relate to, does this exception apply? And for whatever reason, the state's attorney just was not asking the questions that the trial court wanted it to. Now, what should happen in that circumstance is the trial court says, this is your case, state. This is how you want to try it. You have not answered or asked the questions. I haven't heard the proof that I need to hear to rule in your favor. And so without those questions, I'm going to sustain the objection. That's what the trial court did initially. Trial court didn't hear the questions he wanted to hear, so he sustained the objection. Everyone moved on. A new witness was even called. But when the trial court came back to the issue, it more or less took over the role that the state's attorney is meant to function as. And when it did that, it violated the defendant's right to a trial before an impartial tribunal. That is structural constitutional error that requires a new trial. So that's kind of the first bit related to the Goolsbee testimony. The second bit is about the ultimate ruling itself. Now, even after the trial court took over questioning of the witnessing, elicited all of the testimony that might support an application of the excited utterance exception, it still wasn't enough. So when the trial court ultimately allowed the testimony in, it still committed reversible error because this testimony did not fit the excited utterance exception. The excited utterance exception requires a few different things. It requires first that there be an inciting event. We can't identify what that inciting event was because the witness couldn't say. What we have here is a witness who didn't see anything, barely heard anything, couldn't identify any of the parties involved in the conversation, just saying, I heard her, being somebody, say, Ed, don't hurt me. That's all we know. We don't know anything that would be relevant to consideration of is the excited utterance exception applicable. So without those kind of critical findings, and this is kind of spelled out in the brief, but the Supreme Court has laid out what do you need to find the excited utterance exception to be applicable. None of those findings were made. And without any of those findings, the exception shouldn't come into play, and the trial court's ruling was an error. Now, I need to respond, I guess, preemptively to the state's argument. The state's argument doesn't really defend, though it does a little bit, defends the application of the excited utterance exception. What it really does, though, instead is say, this wasn't hearsay. It says, Ed, don't hurt me is not hearsay. First off, I suggested it was, but second, that's not the argument that they made below. The argument they made below was, this is the excited utterance exception. The objection was made before the witness even testified, and that's what the state's attorney jumped to. When the state's attorney did that, it limited what the state can argue. If it wanted to argue this is not hearsay at all, it was free to do that. Instead, it relied on the excited utterance exception.
The trial counsel objected on the basis of relevancy also. Didn't trial counsel also object on the basis of relevancy?
Yes, I believe he did, yes.
All right. If that's what the record shows, and the state is now conceding that it wasn't hearsay, how is the evidence relevant?
I'm not sure I understand the question.
All right. The state at the trial level thought it was admissible hearsay under excited utterance. Is that correct?
Yes, Your Honor.
And the defense counsel objected and said it's inadmissible hearsay and it's not relevant. Okay. Is that right? That's what I've read in one of the briefs, I think.
I think that's right, but I've focused so much on the hearsay component of this that I can't recall specifically
Well,
the nature of the
let's say
relevance.
that I read correctly.
Okay.
And so now on appeal, the state is saying it wasn't hearsay. Well, so the question I have at that point, let's take the state's concession, it's not hearsay. So how is it relevant that Mr. Goolsbee testifies and he can't identify who's saying what or even when it was said? So how is it relevant that some female said, Ed, don't hurt me? How is that even relevant? And it seems it would help your situation by the state conceding that it's not hearsay and then going, how is that even relevant?
I think I see your point.
If it's not offered for the truth
Right.
of the matter asserted, how is that even relevant?
I definitely take that point. I think that's correct, that if the state is now presenting a theory, which again is different from the trial theory, and its theory now is that this was not offered for the truth of the matter, it was just merely offered for its effect on the hearer. I guess
That's not Mr. Goolsbee's what effect. He didn't act on it.
Well, that's where I'm going.
That wouldn't even be relevant.
That's where I'm going. If that is the state's current theory, then I think that is correct.
Okay.
That it would not be relevant, and it would a large part of its irrelevance, I think, would have stemmed from what Mr. Goolsbee didn't know. So when he's testifying, and to be perfectly fair to everyone involved, I think he was just having a lot of difficulty testifying. I think he was a little bit older and was just having some issues that everyone was experiencing. But he could not pinpoint much of anything in the way of specifics. didn't know who was speaking, didn't know what season it was, didn't know what year it was, didn't know when any of this happened or who said what, other than this is this one thing he heard. And this occupied a lot of attention because, and this gets to kind of prejudice and what harm this caused, is the state had very little else to tie Mr. Walsh to the act that led to the victim's death. So the big issue in this case was not who did this, how did this happen, or how did this happen was a big part of it, but the state was really trying to prove premeditation. That was what the state didn't have any evidence of. So what the state was using this Goolsbee bit of testimony for was, oh, this fight happened not in a vacuum, but there was obviously a struggle, and the victim pleaded for something or from help from Mr. Walsh. So this kind of stray bit of testimony that Goolsbee is offering is not without consequence. It does have an effect on how the state was trying its case. It was essential to one of the elements the state was trying to prove. And so that's why it winds up mattering. And the state, yes, trying to use it now by saying, well, it's not offered for the truth of the matter. Well, that's very contrary to what the state was presenting below. At below, the state very much thought this was for the truth of the matter, it asserted. The state was offering this to show that the victim was crying for her life in Mr. Walsh's presence, and that showed premeditation when she ultimately died. So that's what the state's trying to do below. And I think that—
Mr. Ridley, I broke my promise to you. I told you I'd let you know when you got into your rebuttal time.
Oh, I'm already there?
You're already there.
Okay.
Can I ask some questions?
Sure.
A lot of this doesn't make any sense. I've just been trying to formulate a question. So, from reading your brief, he got in a fight, took the knife away from her, put her in a headlock till she passed out, dragged her and put him on the bedroom, placed her in her bed, and then about 2 hours, he came back, she was dead. Is that what he told the police?
Okay, so the part of the brief I think you're going from is from Mr. Walsh's statement to investigators. That's accurate, yes.
Okay, so that's what he told police.
Yes.
And then he said he basically spent the next 2 days digging holes, although he denied dismembering the body and putting them in there. Is that right?
I think that's collapsing a lot of detail into a small bit, but yes, in essence, that's right.
And you're arguing that's not a common scheme.
Well, okay, so that goes back to inextricable connection and mandatory joinder is what you're asking about, or are you asking
Either
about—
one of them.
Okay, so
Same criminal episode or common scheme or plan.
okay, I guess I'll talk about inextricable connection. So mandatory joinder requires inextricable connection, meaning you cannot present one without necessarily impacting the other.
Well, I assume you'd have to present evidence that she was dead before you could be charged with dismembering a corpse.
Well, you would have to show that there was a dead body. I don't think you'd have to show who that dead body was. You just have to show the existence of a corpse and what happened to that
Okay,
corpse.
they showed that.
Yes.
And was she buried in these 2 holes that he dug?
I believe parts of the body were found in one of the holes, yes.
Okay, go ahead.
Okay, but that is not an inextricable connection. You can prove one of those things without proving the other. You can prove the murder. You can prove that there was a killing. You can prove that that killing was unlawful without talking at all about how the body was found. And you can talk about how the body was found without talking at all about how it came to be there, about how this victim came to die. You do not need to talk about how she died to show how she was found. Those are 2 separate questions. And inextricability is a high standard, and it's a high standard that the Supreme Court has articulated time and time again. And its standard was violated in this case.
A lot of criminal offenses that arise from the same criminal episode aren't necessarily connected in proof. Do you
Okay.
agree with that?
I would agree with that, but I think when you're talking about criminal episode in this context, you're not talking about the inextricability required for mandatory joinder, but instead talking about some of the permissive joinder aspects, which I'm happy to talk about, but they are analytically distinct.
All right. How is it not a common scheme from the fact that he murdered her, spent 2 days digging holes, and then cut her up, put her in the holes?
Well, okay, he did not spend those entire 2 days digging the holes. He went to sleep, he went to work. He took breaks. That inextricable connection is required for, or the main thing that's required is that they be connected in time. These were not connected in time. They were long breaks. He was not digging for 48 hours straight from the time the victim was found to when she was recovered.
I didn't say he was. He said it estimated it took him about 2 days and 2 nights to dig the holes. That's his statement, and that's quoted in the brief.
Well, okay. He said that, yes, the entire time took that amount of time, but there were breaks that he discussed repeatedly in his statement to police where he's not digging the entire 48 hours. He went to sleep, he had meals, he went to work. So those breaks, those temporal breaks, and when I'm saying temporal breaks, I'm not inventing that language. That language comes directly from the Supreme Court talking about inextricable connections. If there is a temporal break like that, the Supreme Court has said they are not subject to mandatory joinder.
I thought we were talking about common scheme and plan under permissive joinder.
Okay, if we're talking about common scheme or plan under permissive joinder, here's the part that matters for permissive joinder. They have to be admissible in each other's trials. That second part, I'm not denying that these are related offenses and that there's going to be some overlap in relevance in what you can present in one and what you can present in the other. But you would not be able to present in a simple trial on a relatively low-level felony like abuse of corpse. You would not be able to present all of the evidence that the state presented in this case about how the murder came to happen, how the killing came to happen. This would not be a week-long trial, in other words. If you were just doing a trial on abuse of corpse, you've got a body, you've got what happened to it, and you've got the condition in which it was found. That's not a complicated trial. This becomes a complicated trial when you have a murder attached to it. So that's not saying they aren't part of a common scheme or plan, or not that they're not related. They are related. But evidence of one is not, or all of the evidence of one is not all relevant or not all admissible in the other. So that is the point related to common scheme or plan. Not that they're not related, not that there's not some overlap in relevance, but that more is required for permissive joinder to be applicable. And the trial court saying otherwise was an error. But since I'm certain now I've gone way, way over, I'll reserve the remainder of my time to the extent there is any, and I'll try to maybe touch on the rest of the issues.
Judge Holloway and I have been rather inquisitive. I'll give you 2 more minutes for wrapping up in a rebuttal.
I'll wrap up just real briefly.
No, I'm in a rebuttal.
Oh, okay, okay, fair enough.
State ready.
May it please the court, Clark Horn for the state. Is this microphone on?
You might need to get just a little bit closer to it.
Okay.
Can you pull it toward you, the whole stand?
Yes, sir.
Okay.
I think I'm going to discuss the hearsay issue first, because that seems to be a little more complicated. First off, this testimony of Mr. Goolsby was very confusing, and that was part of the problem. You will see pretty readily when you read the transcript, both in his initial testimony and then a jury out, and then with an offer of proof, and then some more testimony from him, and then when he wrapped up the remainder of his statements to the jury, he's just kind of hard to follow. And part of that, I think, was his age, health. It's a very peculiar dialect that he spoke. But a couple points. The trial court, even though it focused on excited utterance, was correct in that ruling, because the statement itself proved the excitement. There's case law that supports that. She said, "Ed, don't hurt me, I love you." And even though he couldn't say, well, that was her, the victim who said that, the inference was that was the victim, because he testified those were the only people who lived at that house in that direction from where he heard this. Now, it is true he could not say exactly when these statements were made, but they were during the warm months, and after he heard all this, he never saw either one of them again. Well, he didn't see her again, and I believe he also testified that he never saw Mr. Walsh again. So it was admissible and relevant, at least to show that they had hostility between them. It's kind of inconsistent with what Mr. Walsh's testimony was about what happened the night he killed him.
Well, the reason I was asking about, asking defense counsel about the relevance, and if you have, on behalf of the state, you wrote in your brief that it was not hearsay. And if the objection was made based on relevance also, which is kind of unusual, a lot of times lawyers will just object on hearsay and they never mention relevance. But anyway, I think this attorney did object on relevance. If it's not hearsay, then how is it relevant?
Well, if it's not-
You said it's not hearsay because it was a command. Well, then if it's not offered for the truth, then the statement she made was that it was Ed, which this defendant's name is Ed. If it wasn't hearsay, then she might as well have said, Bob, don't hurt me. How is it relevant?
Well, if it's not hearsay, the non-hearsay part is whether or not Ed was about to hit her. That's why we're saying that it's not hearsay. It was relevant to show that they were there, they were in an argument, and it was close in time, at least, to the date of her disappearance.
Well, he could have testified that he heard a commotion and it sounded like a woman. I
He
mean,
could. That's true. We agree with that. But even if it's not hearsay, it's still relevant to show that. But it was properly admitted as an excited utterance is our main position, in addition to not being hearsay. I strongly disagree with Mr. Walsh's characterization of this as being somehow critical for the state to be able to prove premeditation. It was certainly not the only thing that tied Mr. Walsh to the victim's death, and it was not really even essential to the state's case. And it wasn't really emphasized by the state either during its cross-examination of the medical examiner, which I believe is the only time it came up, or during closing argument. It was mentioned, but the main thing that proved the defendant's guilt of first-degree murder were the multiple statements he made that were inconsistent. He kept changing his story, adding facts. He believed that, he told the police he believed he had ruined her she ruined him financially. He admitted he choked her until she was dead. And the medical examiner said that a chokehold, if pressure is applied long enough, will kill you. So, and he didn't render aid when he discovered she wasn't breathing. He pretty quickly, started deciding how he was going to dispose of her body and then set about to do it. And during the next month or so before she came on the radar of the police, he was lying to people about her whereabouts and making jokes about the fact he killed her. And when the police finally found out what had happened, the fact that he had mutilated her body and left it in numerous parts of it in numerous places. Of course, that's very highly probative, and I point to the Davidson case in my brief of hostility and malice and premeditation. That was highly probative to show hostility towards the victim. And and I also want to bring this up, that this constitutional claim that the defendant now is trying to raise there was no objection on that basis. It was not stated in the motion for a new trial. So under State versus Vance, and which really just relied on prior cases, the constitutional ground is not fairly presented. The case of defense relies on regarding the contrary proposition is one where it was obvious we had a double jeopardy claim, because the claim was that the defendant was convicted of 3 separate instances of using a gun during commission of a violent crime, when there was just one crime and one gun. And that was, an implied double jeopardy claim. But the Supreme Court in that case said it was close as to whether it was fairly raised in the motion for a new trial. At any rate, regarding the hearsay, I think that it was properly admitted as an excited utterance, or just as non-hearsay that was relevant for a different purpose. But if it was error to admit this, it was indisputably harmless given all the other proof of defendant's guilt. Now, with respect to the joinder and severance issue, the trial judge really spent a lot of time on this. This hearing went on for quite a bit, and in my opinion, he thoroughly covered the issue. It's mandatory because it is really the same criminal episode, because we're focusing, and I noticed I made this mistake also, that we're kind of focusing on, well, the abuse of the corpse was when he started chopping her up. Well, that's not what the statute says. The statute says a person abuses a corpse when they treat a corpse in a manner that is offensive to the sensibilities of an ordinary person. Now, a couple things about that. First, we only have his word as to when he started cutting her up. And second, in the 2 days that it took him to dig this grave, actually 2 graves, and do these other things, I mean, she's somewhere in his house slowly decomposing. So I believe that under the statute, the abuse of the corpse pretty much happened within hours of her death, when he didn't do what an ordinary person of ordinary sensibility would do, either call a funeral home, call a relative, call the police, report the death. So leaving a decomposing body in your house for 2 days while you're digging a grave and preparing to chop the body up is connected inextricably to the murder of this victim. And the permissive joinder part is, this is definitely a common scheme or plan, because he decided to kill her. He was successful in killing her. He then had a body disposal problem, which he decided to solve by digging not 1 but 2 graves, and then dismembering her, flaying her to reduce her weight. She was not only disposed, you maybe read this in my brief, that in most of her torso was in 1 grave, her head was in another grave, but he admitted that he took a bag of flesh and threw it down in a ravine where it would be eaten by wolves and coyotes. So the dismemberment was extremely important to show this common scheme of, and it was extremely relevant, as I mentioned, to show premeditation and intent, because it showed that he enjoyed doing this. And the cases have held that this kind of mutilation is directly probative of intent, and I direct the court in my brief to this court's opinion in Clymer. So there was no unfair prejudice to. Of course, it's prejudicial, but it was not unfairly prejudicial because this whole thing was part of the same story, and it was an essential part of the proof. And with respect to what this juror said, this was one about, well, I can't separate the two. This is one juror. The trial court, of course, and as defense counsel pointed out, we don't even know if this juror got on the jury, but the trial court gave an instruction exactly how you're supposed to consider the evidence. And the state did not argue that, well, you got to put it all in one ball of wax. The state argued instead that you can take different facts and use them to find one offense, but then you can use those same facts to find another offense. And it was not saying that, it's all one thing. It's just that we've got a whole series of events with numerous facts that kind of go to both the murder and the abuse of the corpse. So we would submit that the defendant got a fair trial. There was no abuse of discretion, which is a standard for permissive joinder, in allowing these two offenses to be tried together, and there was no error at all in admitting this hearsay or not hearsay statement as excited utterance or non-hearsay statement, just for ordinary relevance. So, unless the court has questions about anything else, I'll just leave it at that and ask that you affirm the judgment.
Thank you.
Thank you.
You've got 2 minutes, Mr. Ridley.
I will be very, very brief. And the first and really only thing I want to get across is that the Goolsby testimony, the testimony of Herman Goolsby, very much mattered. The position of the state below was that this testimony was essential to its case, and we know that for a bunch of reasons. We know that first because the state deposed Mr. Goolsby prior to trial to preserve his testimony. If he was so irrelevant, so unnecessary for the state's ultimate case, there was no need to do that. It is not typical for the state to depose witnesses prior to trial. They do it when they know that the witness is critical, or when they believe the witness is critical. So that's fact number one. The state did mention Mr. Goolsby in its closing. And so that's number two. And finally, the state's actions in getting this testimony admitted were extreme. It called Mr. Goolsby, it called him again, and it called him again, and each time it tried to get to elicit this one bit of testimony so it could go forward with its case. Everything the state did below illustrated that the state, at least at the trial court, thought this evidence was critical. Only now that we're in this court and on appeal, does the state all of a sudden say, this didn't really matter. We were going to win this case without it. That fact is proof enough that this testimony mattered. Trial court, or the state below, the DA who was trying this case, thought it mattered, and that's enough for this court to conclude that its admission, if it was erroneous, caused prejudice to the defendant and required reversal. So for that reason, and for the rest of the reasons talked about in this brief, Mr. Walsh asked that his convictions be reversed and the matter sent back for a new trial. Thank you.
Thank you. Thank you for participating today, and I hope everybody remains safe and careful while all this is going on. We'll be in recess until 3:15, I believe.